Thank you so much. A very good morning to all dear attendees. I hope everyone is doing well in these trying and hard times. Myself, Vaishali Sharma, and it gives me immense pleasure in welcoming you all to the very first webinar by Legal Variants. Now, Legal Variants is an initiative to simply help those who wish to either enter the legal fraternity or those who wish to seek help from the legal fraternity to understand the obscure extracts of legal knowledge. For today, the topic as chosen by you all to be decoded is arbitration, inbuilt for business growth and its future in law. To help us all understand the subject, we have with us the expert himself. Ladies and gentlemen, please welcome Advocate Lalit Jain. Mr. Jain started his legal journey by doing LLB from KC Law College, then went on to do LLM in cyber law and IPR from Mumbai University. Then he did Masters in Business Law from NLU Bangalore, followed by his postgraduate diploma in finance management and business administration, IPR, cyber law, brand management, and intellectual property law. He had worked with Kotak Life Insurance as legal manager and then went on to form his own legal firm, The Legal Desk, in 2009. Just 7 months back, he founded his second law firm, Fireflies Legal LLP. Mr. Jain is also an author. He has published a book titled Methods, Strategy, Solutions, Savings on Recovery of Dues with Bloomsbury India Profession, and will soon be publishing 2 more books on the topic of recovery of dues for business entities and arbitration for business entities in India and worldwide. So I have to just sum it up all in a single line. I'll simply say that the man is a walking encyclopedia. And Mr. Jain, it's an honor for us to have you on this platform. Thank you so much for accepting our invitation. Sir, you have muted yourself. I would just request you to unmute.
Thanks, Vaishali. Thanks.
Thank you so much, sir. Now I'll be beginning with our questions. And the very first and the most basic question of all is that what is arbitration and where does this process fall in the whole process of conducting the business of a person?
Okay, so before I answer to your query, let me first inform that I hope that everyone is safe and secure in this COVID times, and the live and let live, that is the best formula today, and if possible, let's help others whatever capacity we can. Now, coming to your query, Vaishali, I understand that you are asking what is arbitration, is it? Now, let me tell you that the whole concept of arbitration is not new in India. Now, let me figure out, let me bifurcate what is arbitration into 2 parts. How arbitration came and now why arbitration? Well, in a very simple language, everyone knows that in India, we had this system of resolving any problem by way of a panchayat, right? Now, how panchayat runs is a very basic thing. गांव के कुछ लोग आएंगे, whatever the issues are, they will discuss, they will mutually talk, and on that day itself or second day, they will sort out the issues. Now, this panchayat, what we used to see in the ancient India, is not nothing but an arbitration. The similar concept is arbitration. Now, the moment I say arbitration, how it works? Arbitration is nothing different than panchayat. The arbitration word itself has its meaning of let's arbitrate, means let's mediate first. If not, let's go to arbitration. If anyone is aware of any law regarding arbitration, the law name itself says Arbitration and Conciliation Act. It means let's try to conciliate first. Let's try to resolve our matter in a very good, amicable manner. If that doesn't work out, go for a mediation. Even that doesn't work out, then the last option, which even the courts now have recognized, is go for arbitration. If you take a technical view, all the 3 are different, but yes, arbitration has got a very famed popularity rather than conciliation, and that's why in India arbitration is more famous than conciliation. Now, how arbitration came, or what is arbitration actually, and how this whole process falls in your business. Now, any businessman, or whoever is the person who is doing a business, if they agree to this fact that they will never get into the legal aspect, or they will, they are free from these legal compliances, then maybe they are making small mistakes, because agreements have become the form of doing a business. Now, definitely you cannot erase the legal disputes. Now, how legal disputes come, it's a fact-to-fact situation part where, I don't want to say, because every business goes with their own fundas. Now, the moment I say there is a contract, arbitration comes into picture. The moment arbitration comes into picture, how it helps, it's a very detailed topic. But let me tell you in one line, it will only help you in resolving your any issues in a very brilliant, amicable manner. Right now, I am talking to you, this is arbitration. The only difference is, today I am not your sole arbitrator. I am just a speaker as of now. But if anyone has any issues, I don't mind to become a sole arbitrator and solve your issues.
Right, sir. And the definition given with reference to panchayat is something which is really easy for us to understand as well. So, but sir, in our day-to-day life, we know that the most conventional step of solving a dispute is by approaching honorable court. So, is there any way where we can say that arbitration is a better way of resolving dispute when compared to litigation?
Okay, now before this, before answering to this better way, let me figure out some facts. In India, maybe somewhere last year in 2020, there were around 6.3 crores MSME registered. And the moment I say 6.3 crore, it means we are taking care of 95% of industries in India. And the moment I say MSME with 6.3 crores with 95%, you can imagine the growth of MSME in coming years. No doubt. Now, why this arbitration? Why we go to the courts? It happens because maybe we don't figure out the condition precedent before entering into any business transactions. Now let me tell you very straightforward. Now most of the MSMEs, now I'm using the word MSME, that doesn't mean that what is defined under the MSME Act. If I say MSME, it means small entrepreneurs. Now the moment I say small entrepreneurs, it doesn't mean that less than 5 crores. No, I'm trying to say for all business house. The reason I'm excluding the big business house because their system is in place. I'm assuming that way. And in fact, if anyone has taken the loan or if anyone has availed any services from the big companies, the best clause you will find is arbitration clause. Now, the moment you have told me to that which is better, arbitration or court, well, let me reframe that way. There is nothing called better or there is nothing called bad. The fact is, what happens is, if you run any business, कोई भी धंधा करते हो, you don't want to get into a legal fight with your client. Because end of the day, कोई भी business house होगा, they want customers. We say customer is a god, right? So let's not debate with the god. Else we know what is going on right now from 2020 to 2021. But the question comes is that suppose if a dispute arises and you have not taken care of yourself, maybe by way of an agreement and any such things, because most of the MSMEs, they don't give so much relevance to having an agreement, issuing the purchase order with terms. They issue the purchase order as such, there are no terms to it. You issue the invoice where there are no with simple way of informing that what my invoice will include. Now suppose there are issues. Any business, there will be some disputes. Disputes are bound to happen, and you have to be very clear on that. Even if you are a masterpiece service provider, or even if your product is brilliant, issues will come. Now the question is, suppose if you don't have this arbitration, now the only step left with you is issue a notice and go to the court. Now the moment I say court, now definitely court is a very traditional concept because more than 80 years, the moment we know anything about resolving the dispute, the court comes into picture. Well, there is also a fact that the moment we say court, अपना मुंह का expression थोड़ा down हो जाता है, because we all know how the courts takes brilliant time in getting the matter resolved. Now this is where arbitration is just an added bonus to all the business houses. Now just assume one of your employee goes to the one of your employee and you are an MSME and you have not executed an appointment letter. And this particular employee, he wants to claim something X and X against you. He goes to the court. Now what happens? You go to the court. And nowadays media are there very clearly. So they will take your particular case to a media. Now this is where even your name of your firm gets little bit diluted. See, you are right or wrong is a different concept. In India, the bad way is even if you are innocent, but media will take you not an innocent till you get anything in your favor. Now, suppose you have an arbitration clause. You should know that anyone, even your employee, is bound by that arbitration. Now, the moment we say why arbitration is better than court, definitely I don't believe in that. But why arbitration is an added bonus? When I say added bonus, it means why it is one of the ingredient in growing your business is any of your matters can get resolved if you have an arbitration clause by way of mediating, conciliating. Even if it go to the arbitration, the matter do get resolved in a very professionally amicable and friendly manner. Because in arbitration, there are no procedures as you will find in the courts. And I'm telling you from my experience, 98% of the business डायरेक्टर्स एंड ओनर्स एक ही इशू आता है सर, वो 11 बजे कोर्ट में जाके शाम तक वेट करने का वो नहीं जमता है, करने का क्या? Now this is where arbitration comes into picture. In arbitration, you are given the time which you want. You have to decide which place you have to do. You have to decide which judge you have to appoint. Every option is with you. Now just imagine that government has given you an act where you decide your own judge, you decide your own place, you decide your own timings. Just imagine what will be the outcome. Definitely the outcome has to be brilliant because there are discussions. The moment you speak to the opposite party, it means even in these bad relations, you are speaking to them. And from my experience, I am telling you, out of 10 arbitrations, 7 arbitration gets resolved in a very beautiful, amicable manner.
Right.
Simple.
Right.
So
there's a high success rate.
Yeah, nothing better, nothing bad. Yes, arbitration is always an added bonus. And the moment if you say added bonus, it becomes your asset. And if it is an asset, I'm pretty much sure it is a part of your growth in your business.
Right. So, Mr. Jain, as you mentioned that there has to be a contractual obligation in arbitration, as in there has to be an arbitration clause in the contract. So, MSMEs, it might happen that they'll forget to add the arbitration clause in their contracts. So then what's the remedy in that case? तब फिर वो कहाँ जाएंगे?
Okay. So I am taking two scenarios now. Prior to when the MSME Act came into picture and post MSME Act came into picture. I will be very happy if anyone who is attending this particular today, that there is a term which has got, nowadays it is getting more popular, is statutory arbitration. The government it has made mandatory that a particular amount of any contract government signs with MSME or other than MSME, they have to go for arbitration. Now, what is statutory arbitration? This is more important. Let me tell you, definitely, if you don't fall under MSME and if you enter into a contract and you don't have arbitration clause, definitely you cannot, go to the arbitration. But you should be aware that even after that, both the parties, if agree, you can enter into an arbitration anytime, even if there is a dispute. But I'm telling you, whoever is the opposite party, he just wants to borrow the time. So, wo to arbitration manne wala nahi hai. And then you go to the court and you fight it out. If you go by 35, you will get the result maybe by 38 or 39, whatever is your age. Now, what government has done? Government have realized that the most affected parties are MSME. So when I said to you that 95% of the industry is run by MSME in India, recovery is a major problem for them. And the moment I say recovery, definitely your money engine gets stuck. And this is where the government came into picture. They said, let's do one thing. forget about this contractual arbitration as of now. Let's come with a new act, MSME Act, Micro, Small, Medium Enterprise Development Act. Now, what this act has done? Now, this act has made mandatory statutory arbitration. Now, this is where the whole game changes now. In fact, now you will find that most of the MSMEs, they directly go to MSME Samadhan website and they try to claim the money. There are certain criterias. Let's not get into that part. Now, what this statutory arbitration has done? Now, suppose there are two MSME, A and B. A have signed one contract or have supplied, he has raised the purchase order, my payment is pending. I will not wait for them. What I will do, I will issue a letter to them saying that my payment is pending, sir. I need this matter to go to MSME Council. Now, the moment your application is accepted, arbitration comes into picture. And I'll tell you the most beautiful part of arbitration. The most beautiful part of MSME arbitration is that the matter has to complete within 6 months. Now, just imagine that you going to an arbitration for closure of your dispute, whatever is a dispute, whatever. But as of now, MS Samadan only takes care of the recovery part. Now, suppose if you go for a recovery and you are in a position to know, definitely I will get within 6 months. It means you are in a better position rather than going to the court. Now, let me tell you what are the two most important part of MSME. Definitely you must be knowing, I am just informing. In MSME, you should know that government has given a mandatory days of making the payment, which is 45 days. And he has also given a mandatory defect period, 15 days. So if the supplier, if the buyer does not raise any claim within 15 days, then he cannot raise any dispute in your product. And he has to make the payment within 45 days. Now, if you read this MSME law along with the Companies Act, MSME have been secured in every way. So now my question comes to MSME, why you should have an arbitration clause even after this statutory arbitration. Now what happens? As of now, MSME Samadhan only takes care of your recovery part. But I am not getting into this recovery now. I am saying, suppose if there are two parties, one has promised that he will supply the goods and you have made the payment. Let me tell you that refunding of payment for any business is not the criteria. What they want, the goods in time. So now what you will do? And this is where your statutory contractual arbitration comes into picture. You have a contractual arbitration. Contractual arbitration means arbitration clause जो आप अपने contract में डालते हैं. Okay? अगर वो है, directly go to arbitration, get interim relief which comes in your favor. Getting an interim relief in arbitration is so fast that it is, you can equivalent give it like IPR interim relief. Nowadays in High Court, the best interim relief you will get, the moment I say best in the faster way, is go for an IPR interim relief. Anyone who practices in IPR, they know you file a case in High Court, second day you get commissioner, fourth day you can add interim relief, fifth day you are finished. This is the way IPR suits works in High Court, and this is the way arbitration works. So definitely you should have an arbitration clause, even if you are an MSM. Prefer that way.
So, Mr. Jain, अपने कॉन्ट्रैक्ट में arbitration clause डालते वक्त वो क्या बातें हैं जो ध्यान में रखनी चाहिए?
हाँ, तो आजकल वैसे भी कंट्रोल सी और कंट्रोल बी का उपयोग बहुत होता है. Technology has given you everything, but definitely technology also makes you lazy. Now, you should never copy paste. You should never do that. I'll tell you, there are, I'm not against online legal services. Let me tell you that. I'm not against them. In fact, they should be there because we have to cater all the segments of the business houses. But at least when you copy paste, you should know what is the interpretation of it. So, I'll tell you, in one of the matter, we got this arbitration clause. I will just read out, if I remember.
Yeah.
All disputes will be referred to Arbitration Act 1947. Now, this agreement was signed in 2019, but they are referring to 1947 Act. So, all dispute will be referred to Arbitration Act 1947. award passed will be final and no appeal. So now you are going beyond President Official Gazette that you cannot appeal. So now what has happened? There was no statement on number of arbitrators, expenses कौन claim करेगा, कैसे करना है. That's why arbitration clause अगर आपको सही में copy करना है, अब एक काम करो. It's a very simple thing. There are only 2 to 3 points which all MSME have to understand. One, make it very clear कि आप कितने arbitrator appoint करोगे. Try to go for one because 3 करोगे उसके expenses ज़्यादा होता है. Go for one. Your seat and the venue should be properly defined. Okay. And third, आपको कौन सा rules apply करना है arbitration का. Now, let me tell you that there is a statutory arbitration under MSME which I have already informed you. You should know that there are 2 ways of other arbitration also. Institutional arbitration, ad hoc. क्या होता है ad hoc बोले तो हम अपने रूल्स खुद बनाते हैं. एक आर्बिट्रेशन होगा, एक आर्बिट्रेटर होगा, बॉम्बे में आर्बिट्रेशन होगा, हम 12 महीने में कंप्लीट करेंगे, खर्चा दोनों यूज करेगा. That's it. Now what has happened? अब definitely we as a lawyer we need to find a loophole. तो हमने भी कर दिया टाइम पास. I am telling you, rather than going for the ad hoc arbitration, go for the institutional arbitration. Now the moment I say institutional, it means like this. Nana Palkiwal Arbitration Center, Chamber of Commerce Arbitration Center, whoever is dealing in the securities, I think you must be knowing that SEBI has its own arbitration, shipping company has its own arbitration. उसी तरह go for the institutional arbitration. You know why? Institutional arbitration का खुद का एक rules book बना हुआ है and they are binding in courts. And I am telling you, my experience is that institutional arbitrations are more favorable, less expensive, even though it is not expensive arbitration, but also it is less expensive. And the matter doesn't take so much time because they have a panel of arbitrators. It is their headache to find out कौन से judge को अपना कौन से arbitrator को रखना है. That is the most part. Because when you have to decide, then definitely you will take reference, you will speak to someone. जितना बड़ा amount उतना बड़ा post. District judge, high court judge, supreme court judge. Thank God उसके आगे कुछ नहीं है. ऐसा है.
Right. So, Mr. Jain, इस सब के बारे में बात करते हुए मेरे दिमाग में एक सवाल आया that many times has it happened that clients directly come to us saying that arbitration award उन्हें directly मिल गया, arbitration summons नहीं आए उन्हें and सीधा award आया. So ऐसी situation में what should the respondent do?
हाँ, ये होता है. I'm telling you कहाँ पे होता है. ये NBFC में होता है. अगर आपने लोन लिया होगा, बिजनेस लोन कोई भी जनता का सहकारी बैंक से लिया होगा, because ये नेशनलाइज्ड बैंक ये सब नहीं करता है, but I'll tell you ये होता है. And most of the time ये okay, let me tell you how this arbitration is also being played. आपने एक बैंक है जिसका बॉम्बे में ब्रांच है, आपने उनसे लोन ले लिया. उनका एक क्लॉज होता है कि आर्बिट्रेशन चेन्नई में होगा. Now definitely पैसा आ रहा है तो no one reads the agreement, तो वो चेन्नई में होता है. तो the moment issue होता है, you are just not aware कि क्या arbitration है क्या नहीं है. Now many of the matters comes to us जहाँ पे ad interim relief 2 दिन में आ गया, समझ गया नहीं, कुछ नहीं गया. इतना see, if I am saying कि arbitration has its own rules, इसका मतलब ये नहीं है that you can make your own knowledge, I mean known fundas, नहीं. Even arbitration has its own system. आपने arbitrator appoint किया, and arbitrator को अपना he has to inform the parties कि I am not a conflicting party to this guy. He has to issue a notice. Before that, the aggrieved party has to issue a notice to you saying that I am going for an arbitration. He has to inform you मैं किसको arbitrator बना रहा हूँ. Now the moment arbitrator appoints, आपको summons आना चाहिए, एक नहीं तो 2 बार. उसके बाद आपका मान लीजिए रिप्लाई नहीं आया, उसके बाद वो हियरिंग के लिए मैटर रखेगा. उसके बाद भी आप नहीं आओगे, एक्स पार्टी ऑर्डर पास होगा, उसके बाद ही आपका हियरिंग होगा और एक्स पार्टी ऑर्डर होगा. बट ये सब चीज़ों को एटलीस्ट 2 महीना जाना चाहिए. आई हैव सीन इन NBFCs एंड अदर मैटर्स 15 दिन में ऑर्डर आ जाता है. एंड मोस्ट ऑफ द देम दे डोंट नो, एंड देन दे फॉर व्हाटएवर रीजन दे मेक द पेमेंट, दे डोंट मेक द पेमेंट, इट इज देयर वर्कलोड. from the legal aspect, I am telling you, अगर आपको ऐसा कोई order आता है, you need to find out कि notice मिला था, summons आया था तो उसमें किसका नाम था arbitrator का, and I am telling you, of late recently there is a new amendment has been made कि arbitrator कौन हो सकता है. A 5-year professional cannot act as an arbitrator. Okay, they cannot. Minimum experience which has been prescribed now is around 10 years, which even I feel it is less because I feel it has to be 15 years. But okay, fair enough. I am not. I don't want to say anything against whoever has passed this. But 10 years is a a minimum experience an arbitrator should possess, even if it's a CEO or firm. So just understand. आप किसको दे रहे हो, क्या दे रहे हो, and then you. And definitely, the moment I say, you should always have someone in with you as a, whoever is your advisor. That's it.
Right. So, sir, moving on to your book, this one statement really attracted me the most in your book, which said, law in itself is a progressive step towards the success of a business. So, I would just really request you to explain this one statement to our attendees.
Okay, I will share you one example actually. Now, there was a startup. Okay, there was a startup and they started the business somewhere in around 2000, I think 17. They started a business. उन्होंने pilot testing किया था. They did everything. Now what happened? That one of the matter went to the civil court, and the matter was recovery of money. I'm just giving you one. See, it's a small example. So what happened? They pitched their idea to this guy, what you call investor. The investor started his R&D, and the investor got to know that there is one litigation going on. So the question was raised कि कंपनी तो आपका अभी स्टार्ट हुआ 6 महीना और अभी से आपका केस हो गया है. I want to know what is the case. So when there was a आन प्रदान हुआ कि केस क्यों हुआ है, the investor got pissed off and he said कि I cannot invest. So moral of the story, the moment you go to arbitration court, you become a public document. बराबर है? Everyone knows किसने क्या केस फाइल किया है. Now this is where arbitration helps you. Arbitration में all your matters are confidential and it is only with you. Number one. So when I say that law is a progressive step, see, if you start any business, nowadays there is a funda that even the startups, they sign the founders agreement. You know why? Because they just want that to be assured and very much sure that whatever we are doing it, there has to be an agreement so that both the minds, all the parties' minds are in one sync. Now, how you do that? Will you go to the Google and get the founders download, free में download करके आप sign कर दोगे? It doesn't work out. Now, the moment I say law is a progressive step, it means that without law, it is actually not practical also to run a business. Because in every step you have to comply the law. The moment I say comply of law, I don't mean CS compliance. No. What I'm trying to say, all the documents have to be in order. There are many cases in MSME especially where we get to know that employee, owner comes to us and says that कि employee हमारा data लेके भाग गया, हम क्या करें? मतलब कुछ मत करो, FIR करो, नहीं तो छोड़ दो. आपने तो अपॉइंटमेंट लेटर भी साइन नहीं किया. Finished.
Right.
I will tell you the best example what has happened with one of our client. They were in the engineering of a plant sort of. So one of the client, he designed this particular कि किस तरह से plant बनना चाहिए. ठीक है. Now it just happened कि everything was exchanged by emails, and suddenly one day उसने वो email अपने आप को email कर दिया in his own personal email ID, and after a few days he was removed from the job for some internal reasons. Now what this employee did, उसने ये design client को directly भेज दिया. So it was our creativity. We have even not settled this particular design. Employee ने भेज दिया. Client called कि आपका design हमको ये email ID से मिला है. Is it true? He said, a client was in a very bad position to say कि हाँ, but nah. I mean to say, I'll tell you why. Because see, any client dealing with you, what they want from you, secrecy. They don't want you to go around the market and jump in the market and say कि ये हो गया ना वो हो गया. No. everyone wants their business trade secret to be confidential. Imagine company, they had a turnover of around 75 crores, even they never executed an appointment letter.
What?
So just
Right.
imagine, because of not complying even with one small issues, they had to face a huge problem. In fact, the tender was, the contract was cancelled on that basis itself. So when I say law is a progressive step, it means that at least I'm not saying you bring law everywhere in your business, but at least you partner with them. Just be aware what you are doing. Trust is a good thing. Let me tell you, any business what you do is a trust. Trust is a very good thing. भरोसा करना चाहिए. But what I'm trying to say, you trust, and if your trust goes with the law, the relation only becomes strong. You should not get into that particular situation where पहले trust था और अभी सिर्फ लड़ाई बाकी है और बीच में कुछ नहीं है. Don't do that.
Right.
So better to be prepared now, and then your relation are very smooth.
Right, sir. And very well stated, the importance of legal compliance for even a very small business or a business with a turnover as large as 75 crores. So moving on, we all know that young lawyers who have just passed out with their law degree, for them, how good of an option is arbitration for their future careers?
I'm telling you, only they have the future nowadays. Because they have got a good years ahead of them to know now what is arbitration. Because see, when arbitration actually came, see, there are laws since 47. The only point comes is usko kitna popularity milta hai. For young lawyers, for freshers, for interns, I will tell you, you should always have 3 years of litigation practice. Now, this is my sincere request to all the interns who are, I'm assuming there are some interns today or lawyers. Have at least 3 years of your litigation practice. After 3 years, you decide that you want to work in a corporate firm, company, law firm, falana. I'm telling you the reason why. The moment you have these 3 years of practice, you are very well aware of the, integrities ki kaise chalta hai courts. Fine. Arbitration mein career, you can become an arbitrator, you can become an arbitration lawyer. Even if you don't be a lawyer in arbitration, that's okay. You just need to be a representative. Let me tell you that. It is not mandatory that a lawyer has to appear, by the way. You practice as an arbitrator or arbitration lawyer, you can become a mediator, you can become a negotiator, you can become a mediator or a conciliator. I mean to say, the journey is too long. In fact, the latest amendment which has been made by the government saying that, what has happened, that they have laid down the criteria who can be an arbitrator. Now, the best part is not about laying down the criteria. The best part is now they have decided that any person who are able to get, they are good in this particular, if they're associated with one of the international arbitration foundation, they will be taken as an arbitrator. Now, you just imagine that suppose if you're a fresher today, I'm assuming if you're a fresher, you must be around 22 or 23 of age. You have your own 3 years of litigation practice, then you do any course on don't do any course. I mean to say, if I say course, no, what I'm trying to say is that if you prefer, you do a course in arbitration in like ICA, CIA sort of, understand how the award has to be written, understand how the civil procedure code works out. Wait for some time, don't jump to become an arbitrator. Give yourself around 7 to 8 years. Understand how the law works, understand how the award decree works. And then maybe by the age of 29, you can become an arbitrator. And definitely the way statutory arbitration has come, the way, even the Supreme Court have understood that, there are, this time has come that everything has to be sorted out in a arbitration way, sort of. Future is huge. But that doesn't mean that at the age of 19 you start becoming an arbitrator. Don't do that. Have some practice with you, understand what is law, and then, because writing an award is equivalent of writing a judgment. I will not compare because they are the judges, but at least that award should make sense. There were certain awards, when the High Court of Bombay was reading, they were so amused, if this is called an award, then I think we should stop arbitration. So you should not get into that. You should not get into that practice. Definitely you have a future, but thoda, अपने आप को थोड़ा time दो, understand law, arbitration, how it works, how to work, how business works. Now, let me just 1 minute. The moment I say how business works, now this is my personal view. Every lawyer should understand how business works. If you really, if you really want to be in the market of being a lawyer who knows business, because as a lawyer, you tend to get into all the legal intricacies. But for a business, you need to understand where to put a full stop. If a lawyer knows how to put a full stop in any matters, this actually helps the business. Definitely your client, because law should not be so stringent in your business, you are not able to do the business. आप comply करो law को in a manner that it suits your business and do the business. That's it.
Thank you so much for the beautiful insight into how to start one's career in arbitration. So as we were talking about legal interns and law students, before starting out the webinar, we had circulated a survey form in which we had asked the interns any of the queries related to the legal fraternity. So there were a few questions. With your permission, I'd like to just ask them out.
Sure.
Yes. So Mr. Jain, first question was that what are the different types of internships that a legal law student can do, and how they would help me, as in the questioner, learn about the law field, and how would that make my CV look good?
This is for me?
Yes, sir. This is a question posted by a law student related to legal internship.
This is one question or 5?
It was a compilation.
Okay. So, एक-एक करके जाते हैं. What was your first question?
Yes. So, how would internships help me learn more about the legal field?
Okay. Now, the whole purpose of intern was, the whole how to start interning with arbitration. Okay. See, the whole purpose of intern is that they should go to a law firm. Okay. And don't try to learn everything in one day. It never happens. I think interns 2-3 महीने का होता है, right? ज़्यादा से ज़्यादा 6 महीने का, if that particular law firm agrees to it. As an intern, the first step is you just understand how the laws are read. Most of the time, हमें ऐसे लगता है कि मैंने एक CBC पढ़ लिया हो गया काम. नहीं, ऐसा नहीं है. What you do, just understand कि law कैसे पढ़ा जाता है. Then you try to understand. If suppose you are doing an intern with a firm who only does litigation, तो पहले आप ये समझो कि वो जो ड्राफ्टिंग करते हैं उसके पीछे इंटेंशन क्या है. Go step by step. As an intern, understand कि पहले तो लॉस कैसे पढ़ा जाता है. Okay, लॉस पढ़ने के बाद हो सके तो 3-4 केस स्टडी पढ़ो. Make your own brief. Don't read everything and then you make your brief. No, read the pleading, make your brief and defense. Then you read WS. The reason is एक बार आप pleadings पढ़ लेते हो. See, you have everything with you, right? I mean to say, suppose आप किधर इंटर्न कर रहे हो, आपके सीनियर ने आपको बोला ये केस चालू है, आप पढ़ो. उसमें प्लीडिंग फाइल हुआ है, WS फाइल हो गया, सब फाइल हो चुका है. Now as an intern वो क्या होने वाला है, आप सब पढ़ लोगे, बाद में बॉस को बोलोगे पढ़ लिया, अभी गया. Don't do that. The best is आप प्लीडिंग पढ़ो, make your defense, discuss with your senior, and then you read WS. Now this is where you will find the loopholes or the minus point in you. Now try to use that and try to upgrade yourself. अगर वो 2 महीने का ही टाइम है तो डोंट रीड एवरीथिंग, जस्ट अंडरस्टैंड ये 2 महीने में वो फॉर्म में क्या होता है, लॉ समझो, किस तरह से हाउ इट वर्क्स आउट, किस तरह से डेट लेना होता है, किस तरह से कोर्ट काम करता है. आई एम टेलिंग यू, आई हैव सीन लॉयर्स इवन आफ्टर 5 years they are not able to understand how to take the bail even in a small case. ये उनका गलती नहीं है. आई एम नॉट सेइंग इट इज देयर फॉल्ट, और वो आना भी चाहिए. बट आई एम ट्राइंग टू से अगर उसने इंटर्न किया होता, दिस शुड बी द फर्स्ट स्टेप. कैसे बेल लेना है, प्रोसीजर क्या है. इंटर्न का यही काम होता है. राइट नाउ ट्राई टू अंडरस्टैंड द लॉ रेदर देन गेटिंग इनटू दिस लॉ. आई नो मेनी पीपल हु नोज, जैसे कि मुझे ड्राफ्टिंग सीखना है. यू कैन नॉट, आई एम टेलिंग यू, इन 2 months, even if you are the brightest child on the earth, it is difficult to start your own drafting. It takes time. आप 10 प्लीडिंग्स पढ़ोगे, then you will be able to, you are in a position to understand कि चलो ड्राफ्टिंग में ऐसे किया जाता है. So that what I'm trying to say कि just understand the law first and then you move ahead. Slowly, भागो मत. आपके साथ एज है. Don't try to collect the certificate for the sake of it.
True. So just believe in the process and keep working. And second question was to how is it going to make my CV look good? So if that's something you to answer.
But first of all, तो lawyers का CV होता ही नहीं है. If I'm not, lawyers का तो profile होता है, right? The moment I said कि don't try to jump and collect the certificates, nowadays I have seen that बहुत सारे interns लोग क्या करते हैं, 2 महीना बॉम्बे, 2 महीना हैदराबाद, 2 महीना एमिनिटी, 2 महीना इधर, ऐसे लगता है कि they are in the IT field and traveling all over the India just to collect the certificate and to put in the CV. But the moment I ask them कि 2 महीने में क्या किया, they are actually not aware. So just forget about it. आप 2 महीना कर रहे हो ना किधर भी, understand that process. और CV को ग्रेड क्या बनाना है, I'm telling you, your CV definitely acts same. Profile आपका definitely कोई भी मेरा profile देखता है. But interns के लिए, you know, this is my personal view. कि instead of seeing the profile, speak to them directly. Understand what they want. Because interns में profile, I don't know how it works. And it's just a weird, you know. You are asking the fresher people कि आपको experience है क्या business के लिए? I don't know experience लाएगा कहाँ से?
So second question was that where should a law student start their first internship? Actually, the first two were from the same girl. So second question was that where should a law student first start their internship?
Law firms, and I will prefer
Law
litigation law firms.
Right.
Again, I am repeating: law firm, litigation law firm,
Litigation law.
And then non-litigation law firm. And then if you want, go to a company. Don't work there for more than 4-5 months. नहीं तो वो नो आपको पैसा मिलता है ना वहाँ पे 15-20 हजार, आप उसमें इतना डूब जाओगे ना तो एक दिन आप वही करते रहोगे. So litigation law firm 6 महीना, non-litigation law firm 6 महीना, company 2 महीना, simple. And then again come back. The day you complete your law, 3 साल तक you should practice.
Right. So, Mr. Jain, I'm a regular reader of your articles that you keep posting on LinkedIn and Tax Guru. One article is specifically my personal favorite. The title is How to Be Unsuccessful. So now, since we are having legal interns, law students, and many people who are just starting their career, I would give a humble request to just state some points from that article as to how can a person be unsuccessful in their life.
You know, the moment you said this particular thing, I am pretty much sure कि यहाँ पे जो भी बैठे ना सबने ये सोचा रहेगा कि how negative question it is. But I tell you कि sometimes negative covenant acts in a positive way for you. See, you know, the day when I wrote this article, there was a reason behind it. You know what has happened nowadays is that nowadays, now this is, I'm just speaking very general. I don't want to pin out anyone. I have seen that, you know, बहुत सारे students हो या कोई भी हो, वो Instagram में बैठे रहेंगे, like करते रहेंगे. They just want to show to the world कि मैं जिंदा हूँ. You know, यहाँ से copy मारा, एक verb डाल दिया. And nowadays this comes on LinkedIn also. I mean to say, आप मतलब, see, don't try to show the world what you are. I mean to say, what they will do for you. You are just wasting your time. You know. Majority, I mean to say, if in a day you have around 8 hours, and I'm telling you, I have seen in the interns. You know, 1 year back, there was an intern which, you know, came to my office. She was spending around 3 hours, Facebook, Instagram, पहले क्या था वो, आजकल Reels आया हुआ है. I mean to say, इतने social, TikTok. I don't know what she was trying to do. 8 घंटे, if she was an intern, she used to come for 8 to 7 hours hardly. उसमें से 3-3.5 घंटा she used to be on the Instagram फलाना. And one day I asked her कि इसका benefit क्या है? Sir, enjoy. I meant to say, if you really want to enjoy, don't join as an intern. I am not saying you don't, you know, you should be aware of what is going on, but don't get into this. Who reads your proverb nowadays? Even Ambani doesn't know when he writes the proverb, when he gets to know from the Facebook that someone has posted his image with the mark. बेचारा उसको भी नहीं मालूम है. The situation is so bad. So, you know, the moment I say unsuccessful, I meant to say, you know, avoid all nonsense. I'm not saying you don't enjoy, but what is the use of this? I'm leaving it to the young generations actually. Give 8 hours of that and do it very properly, and then enjoy your life. Don't post regularly. Nobody is interested except your followers. Maybe paid followers.
Sometimes not even the followers. But yes, moving on. So now it's time to get questions from the audiences that have been asked. I can see in the chat box there are many questions. So one by one, I'll be taking the names and they can unmute themselves and address the question directly to Mr. Jain. So the most recent one is by Mr. Rohit Gulati. So if you are there, you may unmute yourself and directly ask the question.
Yeah, good afternoon, everyone. Rohit Gulati here. Mr. Jain, I have one small question pertaining to arbitration. It was a nice and informative discussion what we have heard from you. Now, my question is how the arbitration award is implemented and complied by both the parties. Simply speaking, who the authority is going to oversee the implementation of the award, and what is the appeal process if the parties are not satisfied with the procedure and the award?
Okay, so okay, Rohit, it's like this. Arbitration award is equivalent to, I will not say decree, but it is equivalent to a decree which is passed by the district court. So if we say arbitration award, it can be appealed, like in Bombay, it has to appeal in High Court. Okay, award has the same status of a decree. Now, suppose if the award it is in your favor, suppose the opposite party has been ordered to pay some 500 rupees to you. He is not paying. What will be your step? First, definitely an arbitrator will issue an arbitration award in 2 copies on 100 rupees stamp paper to you and to him. After that, you issue a letter saying that arbitration award was passed, you are requested to comply with the order. Just wait for 3 months, because 3 months is the appeal period. Suppose if it doesn't file an appeal, okay, then definitely you become you are in a position to claim the money. Now suppose if it doesn't make the payment, you have option like you go to the High Court and file the contempt, that is not making the payment. Now contempt will not be accepted, because most of the time they will say you follow the process. Now what is the process? You go for the decree. So the moment I say decree, it means that you go to the High Court or the equivalent district court wherever the award is passed and claim the attachment of the property of theirs. Now I'm just pausing myself here, Rohit. I'm again going back to the first question which I said, that your condition precedent has to be brilliant. Now what has happened nowadays is that when you go to the court for a decree, court will ask you, आपके पास प्रॉपर्टी डिटेल्स है क्या? अगर है तो आप मुझे बता दो, I'll pass an order against him. But at that particular time we don't have the property details of that particular party. So it is better that you should have a KYC and you should have all the details of the customers. कोई कस्टमर्स देंगे या नहीं देंगे, दैट्स अ डिफरेंट पार्ट. आप डिग्री फाइल कर दो, प्रोसीजर चलता रहेगा. ट्राई फॉर अ कंटेम्प्ट पॉसिबल नहीं है, बट ट्राई फॉर दैट, बिकॉज सी going to the court and getting an order in your favor every time is not a good option. Definitely मिलेगा भी नहीं, but most of the time going to the court and filing an application sometimes adds a pressure to that party. You should do that. So definitely award has a legal value. और जो आपका सेकंड क्वेश्चन था कि अपील, डेफिनेटली अपील होता है. सेक्शन 34 है. सपोज अगर आपके अगेंस्ट में ऑर्डर आया है रोहित, like you pass that, Rohit, you have to pay 500 rupees. You can directly appeal to the High Court. Now the only point is that under section 37 you have to make the deposit of the award which has been passed, which is mandatory. Earlier there was a system of automatic stay which has been removed now. So the moment you file under section 34, you have to comply with 37 by making a deposit. Now suppose if you are not in a position to make the deposit, you have to request to the High Court. If High Court agrees, fair enough, else you have to make the deposit. But yes, the moment I say arbitration award, it is same as court order and it has validity even in India, USA, everywhere.
Okay, so I got your point. Only one thing again, will this not lead to more complications? I mean, more burden in the courts. I mean, arbitration is made ki courts are overburdened, so the procedure is simple and.
I know. See, I'll tell you what. That's why when Vaishali told better option, I use the word not better, but add on. See, end of the day, court will always be there. In fact, what has happened is that slowly the new amendment has come. Maybe after 1 year, what has happened is that even the arbitration, a separate bench has been constituted for arbitration now. And I am pretty much sure that maybe after 3 years or 4 years, you will find a separate arbitral tribunal. You will find that. Okay. But now, as of now, why it will not act as a burden, I'll tell you the way. Now, what has happened is that arbitration has to be completed mandatory within 12 months. Mandatory. If you are not a statutory arbitration. Mandatory. 6 months can be extended with the consent of both the parties. So now what has happened? You have to complete the matter within 18 months. Now here you have to be a very smart guy, because nowadays what has happened, कि उसको मालूम है 18 महीना है, सो वो क्या करेगा, वो 18 महीना मैटर चलाएगा और वहां पे एनसीएलटी में केस कोई और फाइल कर देगा. So this is where, I will say this is one of the loophole where what has happened is that the arbitration award is not being taken as a secured creditor, whereas MSME award is taken as a secured creditor. But 18 महीने में आपका award आ जाता है, you wait for 3 months which is 21 months and directly approach the high court and go for it. अब ये देखो सी कैसा है, धीरे धीरे इवन धीरे धीरे द वे जजमेंट्स आर पास्ड, आई एम प्रीटी मच श्योर कि कोर्ट्स बर्डन को वो कम कर रहे हैं, एंड दे हैव टू डू इट बिकॉज एंड ऑफ द डे आफ्टर द इनेक्टमेंट ऑफ एनसीएलटी, दिस इज माय पर्सनल व्यू. आई होप this is that in future recovery of money has to be taken care by arbitration and NCLT, and no courts have to come in picture, because now NCLT takes care only about 1 crore, right? I will be more happy if it takes above 5 crores and less than 5 crore mandatory arbitration, and arbitration award should be made as secured creditor. But courts का burden थोड़ा तो कम हुआ है, ज़्यादा तो नहीं है, because हम we as a lawyer हम क्या करते थे, suppose if you go to the court, आपने अगर प्लीडिंग्स फाइल किया, हम अपील फाइल करते थे कि प्लीडिंग ही गलत है, बेचारा वो हाई कोर्ट में वापस आता था, हम लोग फिर से अपील करते थे. मतलब वी यूज्ड टू डू एवरीथिंग जितना 10 साल चले मैटर, बट आर्बिट्रेशन हैज क्लोज्ड एवरीथिंग. आर्बिट्रेशन डजंट फॉलो स्ट्रिक्ट रूल्स ऑफ एविडेंस. ऐसा है, कल को अगर आपने नोटरी भी नहीं किया आपने एविडेंस को, दैट इज ओके, बट कोर्ट में नोटरी नहीं किया, इट इज थ्रोन आउट.
Thank you so much.
थैंक्स.
Thank you so much, Mr. Gulati. I hope your query has been solved. Moving on to Omkar Sani, I believe your question has been answered by Sir in our second last question. And then Bhavna Ruya has the question. If she is present over here, she could put it forward to Sir. I believe she's not here. So I'll just ask that question now. How to start interning with arbitration advocates?
How to start?
I'm there, sir. Good afternoon. It was a wonderful session. Sir, I've had a query, like how to start interning with arbitration advocates. And another thing is, I have started law in the later stage of my career. I'm already 45-year-old woman, and I have been working in corporate sector, like under corporate governance and taxation, and also into insolvency. So I just wanted to check, to start practicing as an arbitrator, do I need to have like appear for any examination or any age criteria or any like experience as an under an arbitration advocate?
Okay, I will start one by one, Bhavna ji. I'll start. Number one, how to start interning? कभी भी start करो, that's your choice. Age से क्या करना है? You find a good arbitrator advocate, speak to him and start your intern. Second, age is not a criteria. If you want to become an arbitrator, as per the new amendment, you should have at least 10 years of experience of being an advocate, which has been passed recently. Tisra, since you said that you have started a law, in fact, let me applaud you that at least you have started. I mean to say, I have seen many people saying that मेरा age हो, definitely you are doing at this particular age. I think especially you should applaud it. It's a very good thing. But what I want to say, जैसे मैंने पहले कहा था, आप आर्बिट्रेटर बन जाइए, but as of now आपको 10 साल का दिखाना पड़ेगा, that you have being an advocate. और एक और criteria है, there are criteria कि आपका डिग्री अगर हो गया है, you are in a position to understand कि किस तरह से award लिखा जाता है, and if you are aware of the arbitration, you can still act as an arbitrator. So what I will suggest, you are doing the law, right, Bhavna ji?
Yeah, I will be appearing for final semester in the month of May.
बहुत brilliant है. आप final semester appear कर दीजिए. एक साल आप रुक जाइए. एक साल if possible you work under an arbitrator lawyer, and then you make an application to the Bombay High Court that I want to be under the panel of arbitrator. Definitely they will not accept you, but chances of accepting will be more, because if you are able to prove it that you have an experience to write an award and to understand the CPC, they might take you. Because I know many people, like you started at the age of 45. When I was doing my law, there was a guy who was around 65 and he started doing the law with me. So we both completed. Like when I completed, I was around maybe 24, and he was around 65. Today he has become an arbitrator in before Bombay High Court. So age criteria nahi hai. It's all about knowledge, experience, and the way you can work it out. That's it.
Thank you so much, sir. Thank you.
Anytime.
Thank you so much, Ms. Ruya. And now moving on, hereby we come to an end of the webinar. But yes, I would like to end with a beautiful thought that end of one chapter is just the beginning of another. Read on, the best part is yet to come. So now I would request Advocate Kalyani Tapal to kindly propose the vote of thanks for the today's meeting. Ma'am, you have to unmute yourself.
Now, as we approach the end of this webinar, organized by the Legal Variance, it gives me an immense pleasure to extend heartily vote of thanks. Advocate Kalyani Tapal, the part of Legal Variance, on behalf of my entire legal team, acknowledge our gratitude towards our guest speaker, Advocate Lalit Jain, for gracing the stage with your presence, guidance, and support. I also extend my vote of thanks to all attendee and member of this webinar who are taking the part in this webinar with such a excitement. Thank you all of you. If really you have any, otherwise we will end this seminar. Vaishali, I think one question left. If not, then we can end this.
Oh yes, that had been answered by Sir in question answer round.
From Onila, there is one question. No.
So we are done?
Yes,
So,
we can end this.
thank you so much all dear attendees for being part of this webinar for today. Thank you so much. You all may leave the meeting now. Thank you so much, Sir Lalit sir, for being there.
Thank you.
Thank you, sir.
Thanks. Bye.